Can you sell a home that's inside of a living trust? Yes, and here's how it works. My name is Michael Pevney. I am an estate planning lawyer and I create estate plans for California families. You can follow this page for more estate planning information. I've got a lot of videos out there. Very good chance that your question, if you have one, may have been answered in one of my videos. Please leave an estate planning comment as a question in the comment section. Very good chance I'm able to get back to those. So you have set up a trust and your home is inside of the trust. Now, I don't want to brush by this what seems a simple thing, making sure a home is inside of a trust. A lot of people, when they set up a trust themselves or maybe use a lawyer that doesn't really specialize or focus their practice in estate planning, sometimes their most important asset doesn't make it into the trust. And when I say most important asset, I'm talking about the home, the primary residence. So after an estate plan is set up, it has to be funded, meaning things have to be put inside of it. And yes, for most people, the most important thing to put inside of that trust is the home or any other real estate. So that means not only does a new deed have to be drafted up. So if I'm Michael and I own the home by myself, I would be transferring it from a Michael as an individual to Michael as the trustee of the Michael Living Trust. And then it needs to be signed, notarized, and then it needs to be filed with the county. A lot of people end up skipping this step. Any decent estate planning lawyer should be handling this part of it for you. I don't really let my clients ever put real estate inside of a trust, even if it's out of state. I either do it by myself, or I partner with another attorney in that state to make sure that the trust is properly funded with real estate. So now the home is inside of the trust and you want to sell it. How does that happen? What do you do? So the answer is yes, you can sell it. And it's a matter of typically showing the trust or a copy of that trust or another document called a certificate of trust or certification of trust that pretty much sums up the key terms to the trust. Essentially, that with a living trust, a revocable living trust, which is the type of trust that I create for most of my clients, making sure that it's actually in the trust and that you have control of everything while you are alive. So that document, the trust is going to say whether or not you have control of everything in the trust while you're alive, and you do with most revocable living trusts. And that's going to have to pass muster with the title company because they're going to have to make sure that there is a correct chain of custody or chain of title. And that's going to be all that they need in order for you to be able to sell the home out of the trust. And so then it's simply no longer in the trust anymore. And if you are purchasing a new home, purchasing a new property, if this is a primary residence, you need to make sure that title is taken correctly in the name of that trust. So I sell the home out of the trust, I can take title to that home in the trust as well. And where title is going to be taken in a very similar way. Michael, the trustee of the Michael Living Trust. Sometimes this is something that people forget about as well. Sometimes it requires a call to the lawyer, that sort of thing. Sometimes I do have clients, even though I've instructed them, make sure you take title to things in the name of the trust. Something happens and they buy a home a few years later, then they come back to me and say, oh, you know what? I don't think the home is in the trust. This can be a problem when you pass away, because a trust only controls property that's inside of that trust. So if you pass away and the home's not inside of the trust, we can usually get it inside of the trust following all the terms that the trust lays out, because as part of a typical complete estate plan, we're also going to have a will as part of that. And the beneficiary of the will is not going to necessarily be your kids or whoever your beneficiaries are. The beneficiary of the will is actually going to be the trust itself. So the home, even if it doesn't make it into the trust when you pass away, will make it into the trust as a beneficiary of your will. Now, unfortunately, when it happens that way, sometimes it will have to go through probate, the court probate process, but things will end up going, which can take time, and yes, it can take money, but ultimately it should end up in that trust and being distributed to your beneficiaries in the way that you want it to be. And so, but now what happens when you pass away with that home and the home's inside of the trust? Then we have to follow the terms of the trust. And we can say, well, we want the trustee to have the authority to either keep the home in the trust and maybe the income's going to flow to the beneficiaries, maybe a couple kids equally or not. Or we can give specific instructions to that trustee that this home is to be sold from that trust. In order to get the authority to do that, we have to file a substitution of trustee or an affidavit of a death of a trustee with the county records office, showing that essentially the new trustee, the new person, a trustee is essentially equivalent to the executor of a will, and we're going to need to file that with the county along with a death certificate. This puts the new trustee in control of things and gives them the legal authority to sell the home if they want to and if the trust requires it. A lot of people want their home to be passed down generation by generation, but that can get a little bit difficult when we've got a bunch of kids. So if there's 2 kids, 3 kids, and now each of them has a couple of kids, so you've got 3, 4, 5, 6, 7, 8, 9 grandkids out there, typically we don't want all of them on the title to the house. So yes, the simplest thing is usually going to be for the trustee, one successor trustee, to sell the home and then divvy up the proceeds and the profits. However, if it's very important to you and very important to some of my clients that the home stay in the family for generations, and we can do that by using a trust. But that means this trust is going to be ongoing. We're going to need to make sure that we know where mortgage payments are coming from, property taxes are coming from, upkeep is coming from, and that sort of thing. So while you are alive, you have complete control of everything inside of the trust, including real estate when we're talking about a typical revocable living trust. And then when you pass away, you also have control of what happens to it. So that's just a brief overview of what happens. How do you get a home out of a trust? You can sell it while you're alive, typically, and it has to follow the terms of the trust to properly get it to the beneficiaries once you pass away. So once again, my name is Michael Pevney. I am an estate planning lawyer. I practice in California, although much of what I said may be applicable to the state you live in. And again, if you have any other estate planning questions, go ahead and ask them in the comments. Follow me for more estate planning information. And if you're in California and you don't have an estate plan set up and it's time to get on that, you will find information in the description on how best to get to talk to me. So I appreciate your time and appreciate your attention. Thanks.